Honorable Gbajabiamila, the minority leader in the House, joins us today via phone to speak on that matter and a lot more matters. Morning, and thank you for joining us today. Take us through what transpired there. First and foremost, it had to do with the fact that they talked about those matters being in court. What happened on the day, by the way?
Well, first of all, thank you, Chamberlain. Let me first of all tell you exactly what the rules of the House say. But if there's a case in court, and if it's in the opinion of the Speaker, it will be prejudicial to the outcome of that case, then the Speaker may, in his discretion, decide not to take that debate. So it's not absolute that if there's a case in court, you don't discuss it. It's not absolute. It's absolute discretion of the Speaker. Because if it were absolute, then we will not do anything in the House. Because invariably, half the taxing cases are in court anyway. All right. So now, this matter was brought up a week ago. The Speaker referred it to 3 committees. The objection was principally that the case was in court. And that was the terms of reference. Advise us whether the case is in court or not, and whether or not it will be prejudicial. And that was simply what they were asked to do. Now, the Chairman of Business and Rules came back yesterday and basically went into the merits of my motion. He basically debated the motion. He went into the Constitution and gave his own opinion and his argument. Now, whereas you're saying that the case is not supposed to be debated if it's in court, but you're now here debating the case, and you expect us to swallow everything, hook, line, and sinker. So you've gone outside the terms of reference, number one. Number two, I mean, I've been privy to see the report that he presented. It was signed by only one person. It was a 3-man committee. I am yet to, I do not believe, and facts that have come up indicate that this was a one-man show. So it's something that we definitely are objecting to. Now, in his presentation report, he went further. What he did was basically to sit in appeal, to a court judgment, and he overruled the Court of Appeal. That's what he was doing. There is a sitting of 2 court judgments already, one from Sokoto Federal High Court, one from the Appeal Court. Now, what Sam Sokwa did was to sit in judgment over those decisions and overturn those decisions. It's as simple as that. Where is the separation of powers?
Okay, so, but you then said in that previous film, which we also played not long ago, that you will get back to the House, raise that matter, and so it will be discussed again generally. Is that the intention?
Well, that is the intention. We will be back in the House today. We'll roll with the punches. We'll see what happens. But yes, that is the intention. We're not just going to roll over and die, which is what is expected. And let the chips fall wherever they may.
So let's understand the purpose of you bringing it on the floor of the House in the first instance. Is it to ensure that the executive arm of government obeys those court orders?
It was as simple as that. There are 2 court decisions. Hey, let's respect God. Let's obey the court decisions. Especially in light of what happened with the Ekiti tape, which everybody seems to be ignoring. The audio tape from Ekiti. Everybody seems to be ignoring that. So, I mean, we tie that in. We tie that into the motion and give some kind of a flip to the decision of the court. It was as simple as that.
But I've heard some lawyers, SANs inclusive, say that judgment, both of them, first Sokoto High Court and then Court of Appeal, may not have been given in the context of Section 218, which gives the President powers to deploy the military for the elections to quell insurrection, and as he says in the section there.
Well, I'm sure before, we're talking about 2 courts of competent jurisdiction, Federal High Court and the Court of Appeal. Before they could make a clear, definite pronouncement, they would have taken every provision of the law, constitution, or extant law into consideration. I mean, give credit to the court. They will not just come and give an opinion or give a judgment without considering all the facts and all the laws. So I mean, it's pretty clear to me. And when you quote Section 217, it's better we don't quote it. It's good we don't quote it out of context. Insurrection. There is no insurrection in elections. That's not what the Constitution is talking about. Okay, go ahead.
If the House debates that matter, comes up with a decision, is the president bound to obey whatever outcome of the House of Reps matter? Because, I mean, there's a court judgment there. So would he disregard the court judgment and then obey the House, or is he not bound to obey the court judgment? Especially if they also think, look, well, we can appeal this matter. What's the hue and cry about it?
Yeah, I mean, if anybody is not satisfied with the court judgment, I mean, there's a procedure, you appeal it, right? And all we were doing was to seek to give some kind of support to that court judgment. At the end of the day, a court judgment is a court judgment. We mouth the rule of law. We should act the rule of law. Okay, if they're dissatisfied with the court judgment, go to court, and that's my position. Otherwise, the judgment stands.
Yeah, but
and the House bringing up a motion for you to obey the court judgment itself is an indication, perhaps, that you don't obey court judgments. Otherwise, there will be no need for it.
Okay. Now, first of all, the question will be, since when did the House of Representatives need to start sitting to give support to court judgments on the one hand, and what makes you think that this court judgment might not be obeyed in the second instance?
Well, first of all, the jobs of government, okay, and each arm is meant to complement each other. So if the House brings up a motion, it's not out of place. That, hey, just in case you don't know, just in case you're not aware, there is a court judgment. Let us follow that court judgment. Because based on antecedents, there has been deployment of military in the past. Okay? But now we have an intervention of the court, the only authority that has the right to interpret the Constitution, and nobody else. And so we're bringing that to the knowledge of the executive and to the knowledge of even the legislature itself. There's nothing wrong with that. It's a complementary role.
In the House, are you seeing any circumstance, even though your party is saying that, this is the court judgment and we want this court judgment obeyed, are you seeing any other circumstance under which the military can be deployed, especially as regards to 2015 elections?
For me, the question is that what is the role of the police? And I'm sure the court must have considered this as well. You don't make your police force redundant. You don't weaken an institution to strengthen another institution. It just doesn't work that way. Okay, now, if there are circumstances where the military can be deployed, it will be clear in the Constitution. If you're talking about the Constitution does say in aid of civil authority, but the Constitution anticipates that there would have been some kind of development for you before you deploy them, to quell whatever that development is, not in anticipation. That's a different. The language of the Constitution is very clear, and it was chosen deliberately by the drafters of the Constitution. You don't bring the military. That's not the traditional role. To come and stand. The fact that the military. If I look out of my window in some places, if you look out of your window and you see men, decked out in their full regalia, military men with gun-toting military men. You may even be dissuaded from coming out to vote. So, if there are circumstances that require for the military to come out, then you do that at that point in time when that has happened.